there. I can see all the wheels spinning from here. But if you would please take your seats. As you can hear, the acoustics are not the best. And so it's very hard to understand sometimes. So I appreciate your courtesy and your cooperation. That being said, we do have several items on the agenda. And looking at the cards, we have a hefty one. I wonder which item that one is. So let's run through the agenda, and I want to welcome and thank the Honorable Councilmember Jose Huizar. And are we expecting Councilmember Krikorian today? Do we know?
No, Councilman.
Okay.
No.
Pretty good timing. And I appreciate his hard work. He's always very diligent, too. We have several items that we can move, and seeing no cards, Councilman, let me just kind of go through this and see if you're okay with that. Item 1, we do have a candidate. And Roberto, you want to speak to the item number 1?
Sure. Council members, item 1 is a communication from the mayor. It's relative to the reappointment of Mr. Young Kim to the Central Area Planning Commission.
Mr. Kim, are you here today? Good afternoon, sir.
Good afternoon.
Thank you for your participation. I know that you are giving a lot of your time, expertise for this city, and for that I thank you. These are volunteer positions.
Yes.
So planning and land use is probably one of the most direct ways that this city impacts our citizenry. So that being said, would you like to share with the committee your background and your thoughts on why you would be a good candidate for this commission?
Thank you very much. Thank you for the opportunity to serve the city again.
And if you don't mind speaking right into the microphone, you're set.
Thank you very much. Thank you again for the opportunity to serve the city again. Since 2002, under Mayor Han, I was appointed to the Central Area Planning Commission. Then I was reappointed under Mayor Villaraigosa, and right now this is my third term appointment as Commissioner for the Central Area Planning Commission. I'm an attorney by trade since 1995, and since 2002 I've been on the commission, so I've had the opportunity to learn quite a bit about community impacts, about the city functions, and about the need for growth, but at the same time keeping in line with all the community concerns as well as future development prospects.
I want to thank you. This is the third round, so you're probably one of the veterans.
Round number 3, yes, sir.
Great. Again, thank you for your hard work. The Central Area is a very dynamic place, going through many changes. And again, appreciate your expertise. Councilman, any other comments? That being said, I'd like to vote in support of your appointment. And do we have a date for the commissioner?
Yes, you'll be in council on Tuesday, August 16th.
August 16th, okay. That being said, thank you again so much. I appreciate everything you do. And any last comments or words or observations?
Thank you very much for the opportunity to serve the city again.
Okay, sir. Look forward to seeing you.
Thank you.
Take care. All right, that takes care of item number 1. We have another reappointment, and with us, Roberto, you want to?
Item 2, council members, it's a communication from the mayor again. It's relative to the reappointment of Ms. Noel Guzman to the South Valley APC.
Hello, Ms. Guzman. Come on down. Hi, is this your second or third tour?
Only my second.
Only your second, all right. And this is for the South Valley area.
Yes.
And again, thank you for your commitment. Anything you'd like to add or share with us in terms of your experience and issues you might want to bring up? I mean, it's rarely we get to have this conversation.
Sure. I was originally appointed in 2008 to the South Valley. My day job is I'm a business consultant, and I'm also very involved in my neighborhood council and in our economic development in that area. I got involved in that to just try to help I live in the city of Reseda, just help them kind of reach the full potential of that city. And I look at with this commission as an opportunity to, work with planning and work with the community to just help Los Angeles just be better in our South Valley area.
Great. Again, thank you again for your stewardship and everything you do for the city. Any questions, Councilor? So we would move to recommend you for the reappointment.
Thank you.
Thank you, ma'am. Next, Roberto.
That would be item 3, council members. It's a communication from the mayor relative to the reappointment of Ms. Candy Lewis to the Harbor APC.
Ms. Lewis. Good afternoon, ma'am. I think you're hearing a pause. How are you?
Good afternoon. I'm fine. How are you?
Okay.
Gentlemen.
And this also is what, your second or third tour?
Well, actually, this is going to be my first full appointment.
Oh.
I just took over for someone for a short period of time last year.
I said you filled in someone's time.
Yes.
Got you. And that is for the harbor area. Anything you'd like to share with this committee in terms of your experience or what you'd like to look forward to? Any observations or comments?
Yes, I'm born and raised in Los Angeles, a 30-year resident in the Area 15, so I have lots of experience. I have not only a small business, but I also have a nonprofit, and it's been a wonderful and honorable experience being on the commission. Love to see more businesses in the community, so that's a wonderful thing. We're starting to see a lot more business come back.
Great. Well, in the harbor area, there are so many different, how can I put this, environments you could generate using the land use laws and planning principles, and hopefully the creativity and how we create a sense of place can be stimulated through your insight and the cooperation of your colleagues in that commission.
Yes.
So that being said, I want to say thank you for your hard work, and any questions or observations from my colleagues for our reappointment? That being said, thank you so much, and we will reappoint you. That'll be a recommendation from this committee.
Thank you very much.
Thank you, ma'am.
Have a great day.
You too. Okay, then we have here, Roberto, are those all the reappointments?
Yes, Councilman.
So we don't have any cards on 4, and that is can you read that into the record?
Sure. Item 4, council members, it's a communication from Council District 5. It's relative to the clearance of Quimby conditions and to enter into a proposed 3-party agreement between the city, county, and the developer for a proposed 264-unit project in CD5 for the construction of a River Greenway Park. And this is in response to a motion by Council Members Koretz and yourself.
So we do have one speaker card, and Mr. Coons representing Councilmember Koretz. Good afternoon, sir.
Good afternoon. I think it may be helpful to hear from the city attorney that's been working with us on this project first so that we can get everything correct on the record.
Okay.
Good afternoon, Deputy City Attorney Arletta Brimsey.
Good afternoon.
In response to the council motion, my office, City Attorney's Office, we've met with the council office and with the developer and in an effort to try to address the motion. And we've come to the conclusion that the condition number 10, the payment of the Quimby fees, will be satisfied by the developer paying the fee. The fee would then be accepted by the Department of Recreation and Parks, which is required by the Quimby ordinance. The funds will be placed into a trust account and held. Rec and Parks staff will make a recommendation to the Board of Recreation and Park Commissioners to conceptually approve the concept of entering into a long-term lease with the county. And this will be a 3-party agreement between the county, the developer, and the city. As I said before, it would be a long-term lease of the county's property, which is adjacent to this development. The Quimby fees would be used to pay the developer under a sole source contract. The developer would then construct the park on the county property, and would also agree to a 30-year maintenance agreement to maintain the property for 30 years. Thereafter, the county would then extend the lease to the city, and then Rec and Parks would take over maintenance.
Great, I congratulate you, because I know when they first came up here, we were kind of like looking this way and that way and upside,
Took me a while.
sideways.
I got
And you
there.
come back with a very clear directive as to how we can reach our goals, and there's still
There's still other steps.
other channels that need to be addressed,
Right,
so
but-
to speak.
This is true, but we are moving forward, and the first step will be the developer clearing condition number 10 by paying the fee. Rec and Parks accepting the fee and putting it into a trust account. We're going to try to get this on the Rec and Parks agenda for their September 7th meeting, the conceptual approval of the concept moving forward, and we're working with the county's office to draft the three-party agreement. So we're moving forward, and
Well, thank you, I appreciate the
get there.
can-do spirit here of the city attorney's office and giving us direction. Thank you so much.
you're welcome.
We also have one more speaker.
We submitted a letter that describes everything that I've just stated. It's a letter from Rec and Parks to the developer stating how we're moving forward.
Great. Any questions from my colleagues on this one? Seeing none? Thank you very much, ma'am.
Thank
We
you.
also have one more speaker card, as Amy Freilich. Hi. Good afternoon.
Good afternoon. I'm Amy Freilich with Armbruster, Goldsmith, and Delvac. I'm here on behalf of IMT Capital. I don't have very much to add to the report, except that we are very pleased to be working with Rec and Parks and with the City Attorney's Office. We appreciate these efforts, and we do intend to move forward on September 7th expeditiously to Rec and Parks and then pay the Quimby fees, and we hope to have a park and a ribbon cutting shortly. So thank you very
Ms.
much.
Freilich.
We appreciate it.
Thank you very much. Any closing comments before we move the directive?
Christopher Kuntz on behalf of Councilman Paul Koretz. I just want to thank the staff for their really hard work, and I'm looking forward to moving this item. I hope that at some point in the future we can revisit the more global issue, because everyone worked really hard and we got it done over the course of several months. But if we want to do parks together with developers in the county, we need a more straightforward path to do that in the future.
Well, you are touching on a multi-jurisdictional location.
Right.
And I hear what you're saying, but sometimes we have what we have and we make the best of it.
Right.
I think you've done that.
And we've done great. Thank you.
Thank you, sir. That being said, we could refer to the item to the Arts, Parks, Health, and Aging Committee, inasmuch as the proposed agreement needs to be considered by the Department of Recreation and Parks.
And also to concur with the city attorney recommendations.
Okay, and I happen to sit on that committee too, right? Yeah, okay.
That's right, you sit in that committee.
All right.
So you will see it again.
Thank you very much, Roberto. All right. And I don't see the director here for special notes. And then the rest is the big ticket item here. I don't think we can all say we all agree and stand up, right? No, okay. Wishful thinking. Okay, Roberto, drum roll.
Okay, item 5, council members, the remaining item, it's a report from the planning department. It's a proposed ordinance to regulate signs in the city.
Okay, so let's begin with the report from the planning department. And just to kind of give you an overview of how we're going to proceed in this item, we'll have the report first, then we'll ask if the city attorney has anything else to add. It's their discretion. Then we'll ask my colleagues if they have any comments or questions. Then we'll begin public comment, and then we'll go from there. Please identify yourself. Please, Councilman.
Thank you, Mr. Chair. I just want to be clear, the planning department passed out some additional documents, and I just want to make sure they are from the planning department. They're not, doesn't say who they're from. There's one we got called additional recommended changes. Is that from the planning department?
Correct. Those are all from the planning department.
And grandfathering of pending sign districts?
Yes, those are documents that we just prepared.
We got a number of documents up here. I just want to make sure which ones are coming from who. Pending sign districts initiated by city council motions, planning department, and then your presentation, and then we have a lot of stakeholder letters here. Okay, got it. Thank you.
And I just also want to say that all of those documents that we're passing out today, we will be posting those on our website for public access today, later this week. So I'll be starting off with the presentation. Who will be assisting me are some of the key staff within the planning department. Daisy, pardon me? Alan Bell.
And who is Alan Bell?
Good question.
How about giving us your title?
Pardon me?
Your title as well?
Deputy Director of the Planning Department.
Thank you, Mr. Bell.
So assisting me today will be Daisy Moe, who's been the key drafter of these sign regulations. We also have Kevin Keller, one of the senior planners in the department, and he's really our expert on sign districts and was played a key role, for example, in the recent adoption of the Wilshire Grand sign district, and then also Tanner Blackman. So what I want to start off today is just giving a brief overview in terms of why we are here today, what has happened within the last couple of years, and then the path that we see moving forward. So basically, why are we here today? In 2002, the City Council adopted a ban on supergraphics and off-site signs, and that was a fundamental policy change from the city's prior sign code ordinance, which was adopted in 1986. And I think at that time there was a significant agreement that that particular sign code from 1986 was not doing what it was intended to do, which was to reduce visual clutter and clean up our environment. So the council adopted a ban on off-site signs, but at the same time the council also adopted an exception clause from that fundamental city policy called a sign district. So one of the reasons why we are here today is because there was litigation concerning the city's granting of exceptions through specific plans and through sign districts. A court found that the city's application of that ban was invalid, and there proceeded a protracted period of litigation in front of the courts in a case called Worldwide Rush. The ultimate outcome of that particular litigation was that an appeal court upheld the city's current regulatory scheme for signs and sign districts, basically finding that we can have a citywide ban, and at the same time we can have sign districts that will allow exception from that ban, but only so long as we have certain very narrowly circumscribed rules. And the basic rules that the court found are that if we are going to grant an exception from that ban, it should relate to the reason why we had the ban in the first place.
Mr. Bell, and if I may just interject here, I just wanted to reach back a little bit farther in terms of context, and that in 2001 and 2002, this body deliberated for almost 2 years, almost 2.5 years, with the then council to talk about the creation of these sign use districts. And it's been in the courts for almost 10 years, almost 11 years. And the reason why I bring that up is we were trying our best at that time to create parameters and regulations that were consistent throughout the city. But because of exemptions, that was called into question, as you did describe. So colleagues, a lot of the vetting that occurred 10, 11, 12 years ago did result in what we see today in SUD, but it still, I believe, requires that we continue down the road that speaks to how we could create consensus within this policy so that we can be consistent with a set of parameters that allows stakeholders in respective areas to define their own space that's consistent with how these SUDs can perform. And that is, I think, one of the crucial aspects of this discussion and dialogue is defining these parameters and setting those regulations so that we can be consistent with the court rulings. But that does not mean that we don't have more court cases to engage. Those are still in the horizon, and they're coming into their own maturity, if you will, in how those are being discussed, and they will be folded in the future. So this, to me, is a discussion of a foundation and trying to establish that discourse that allows what Mr. Bell is going to continue to describe. But I needed to put it back in the context of those who were working back in 2001, 2002 on this particular policy issue. Thank you, Mr. Bell.
Yeah. Yes, that's absolutely correct. And then just also some additional context. Because the city did lose in a lower court, which found that the ban was invalid because it offended the First Amendment, there was a significant effort that was initiated 2 years ago to try to address that particular situation. We were instructed by Plum at that time to embark on an accelerated schedule. We presented an ordinance before a decision on Worldwide Rush was handed down to the Planning Commission. There were multiple hearings. Ultimately, it went before Plum. Plum did in fact take an action in 2009 and forwarded a recommended ordinance to the full council. I think there were approximately 20 amending motions to that particular ordinance, and at the end of the day, council did not take an action on either the CPC recommendation or the Plum recommendation from 2 years ago, and remanded the ordinance as well as all the amending motions back to Plum. And the direction at that time was that we would wait until there was a decision handed out in Worldwide Rush. As an intervening measure, what the council did do was it adopted a flat absolute ban on super graphics and off-site signs pending a resolution of Worldwide Rush. So we have had for I think close to a year now the court's decision. So all of those regulations that the council adopted in 2002 relative to sign districts and their establishment are in effect today. And the question before this committee is, to what extent do we need to reshape, refashion our basic foundational sign code regulations in response to the decision handed out in Worldwide Rush, and to provide basic ground rules so that we provide clarity for the community in terms of what expectations they should have in terms of our basic regulations, clarity and ground rules in terms of when we would grant an exception, and also to really kind of head off the possibility of future litigation, and if should there be litigation, that we would be able to prevail. Ultimately is to protect the integrity of the citywide sign ban so that we do not get into a situation where we have a regulatory scheme that would allow exceptions to the basic rule, essentially could swallow up that particular rule. So what we're recommending today, based upon direction that Plum provided to us approximately 6 months ago, was that we narrow the scope of this particular ordinance. One of the key directions that came from Plum was that we do not include recommendations that would limit commercial on-site business signage until at least 2 years have passed after a systematic sign code administration program, or SCAP, has been adopted. So we have followed that particular direction from Plum, and the ordinance before you today does not include restrictions on commercial on-site signage. Other than that basic change, what we are recommending today is substantially the same as what we recommended 2 years ago, and substantially the same as Plum's vote to send that ordinance onto the full City Council for approval. So let me go through what we think this ordinance does, and there are 5 main provisions to this particular ordinance. Number 1, it establishes rules and findings and guidelines for establishment of sign districts. It includes specific findings that the court have found are important to grant exceptions from the sign ban. It includes a 3-tiered system of considering requests for deviations from the citywide sign code, And it also establishes what we would consider to be very reasonable limitations on the granting of those exceptions. It establishes minimal standards for digital signs, both on-site digital signs as well as off-site digital signs. One of the nuances of this ordinance today, any on-site sign is allowable to be a digital sign. And we have no standards for the brightness or the message duration of any digital sign. One of the motions that was referred back to Plum was to, as a follow-up measure, adopt and develop regulations concerning digital signs. But we think, given the importance of this issue, that we should adopt minimal standards as a baseline for all digital signs. Also, the ordinance includes administrative civil penalties. One of the issues that came up in all the various hearings was the need for stronger provisions to enforce our sign code, particularly for violations of the off-site ban because of the amount of profit that can be generated by putting up these illegal signs. And there was great support 2 years ago for strong civil penalties, so those provisions have been substantially retained. And then finally, the ordinance includes various technical and clarifying changes.
One of the lessons learned in these 10 years was the notion of enforcement. I think what crippled the city for a long period of time is that we did not have the infrastructure, the database, we didn't have the personnel. There was always a reason why we could not keep in check the voluminous number of signs that went up overnight in some cases. And to have the capacity to enforce is critical, so I appreciate that element of it too, because it created severe tension and for many people very punitive to some neighborhoods and how that came up.
Right.
So I appreciate that.
One of the things that we learned in going through this process is that when you look at the professional literature, it said that developing a sign code is probably the most complex, most challenging kind of zoning code regulation that any city can adopt, and I'm here to testify that in fact is true. So I think one of the lessons going forward is that we need to take incremental steps to developing our city's sign regulations. So many of the motions that were referred back to Plum are not included within this particular ordinance, and in the last few months we have had an opportunity to engage in dialogue with the business community, and many proposals that we think are meritorious and should be addressed and are part of a valid, true, comprehensive sign code should be addressed going forward, and I want to touch briefly upon those. And one of those issues has to do with existing off-site signs that were constructed before the city's ban went into effect in 2002. Many of those signs have been up for many years, but there may be some slight deviations in terms of those existing off-site signs in terms of their size and their area. One of our recommendations for on-site signs is a sign adjustment procedure that would allow consideration of minor deviations from the sign code regulations in terms of height and area. We think that to remedy this situation, we think that an analogous procedure should be adopted as part of this ordinance going forward for those existing signs that have been up for a significant period of time, to consider legalizing those if they have features of those signs that are not consistent with regulations that were in effect at the time that they went up. We don't think that this would be a complex procedure and is something that could be addressed as part of this particular ordinance. On a longer-term schedule, we would recommend establishment of a sign unit. We did submit this request as part of our budget package to not only be the unit that would be specially trained to process applications for sign programs and for sign districts, but would also address some of these very complex citywide policy issues that are of strong interest to the City Council that we think would, in toto, would do this, the city good as far as preventing future litigation. So there are 4 issues that we believe should be addressed going forward on an incremental basis. First is reduction and relocation agreements. The State Business and Professions Code does not allow us to mandate the takedown of a non-conforming off-site sign without providing just compensation. So the tools that are available to the city to take down existing signage that is non-conforming, that has a legal non-conforming right to remain, are extremely limited. But the State Business and Professions Code does permit reduction and relocation agreements, and this could be, based upon the details of that, be a very powerful tool for reducing the signage and replacing it with a much smaller number of modern signs, and reducing, on an overall basis within the city, the impact of the approximate 10,000 signs that we have in our inventory. I mean, LA really is the billboard capital, and this would be an opportunity to significantly reduce that in exchange for newer signs. It's a complex issue. Other cities have successfully tackled it. The devil is always in the details and trying to get the best deal for the city in terms of, in exchange for putting up a new sign, how many existing signs should come down. But it merits further study, and it's something that we feel should be addressed through a sign unit. The second issue that...
Alan, before you go to the second
Yes.
one, on that first point, just amplify the notion of exchanging reduction and relocation happens within each sign use district, correct?
It could happen outside of sign districts also,
It could, okay.
depending upon the legislative intent, but I think that we have authority within the state code to enter into these kinds of agreements. I think that it is a policy that the council should consider, because if you do it right, there could be a win-win really for the community as well as for the sign industry, because of our limited opportunities to take down existing non-conforming signs.
So what could happen in the Granada Hills area might be different from Venice, might differ from Westwood, might differ from East LA. I mean, that's the nature of the complexity of our discussion.
Every community is different. Where the signs are located, where the sign should be taken down, that's one of the issues that have to be addressed. But probably the biggest issue would be what would be the ratio? What would be a fair deal for the city? And I think this is where the experience from other cities, hopefully we would get funding for a consultant to take a look at it. Essentially, it's a negotiation between the city and the sign company to say we would allow a new sign to go up in exchange for taking down so many existing signs.
So we have to, I'm not sure how else to say this, but request a lot of patience at this stage, because we're not there yet. What you're doing today is laying out the foundation for that discussion. We still have to look at resources and giving you the tools and personnel to get that economic analysis, to establish those perspectives, to understand those ratios, to learn what the industry knows in terms of what value means based on geography and location and exchange rates. All that still has to be hammered out in the near future.
Absolutely, and there is a council motion to that effect that has been referred to Plum. So this would be a way of addressing that particular policy interest on the part of the councils.
Just exciting things to come, right?
Second issue is revenue generation. I mean, we have a budget crisis in the city, and one of the issues is there a way to create a mechanism where the city can financially benefit from off-site signage going up? What the city attorney has said is that a billboard tax is a legal means for doing that, and that also off-site signs put on city property where the city is a landlord, that is also a legal mechanism. I think that particular policy issue could also be linked up with an approach to reduction and relocation agreements. So, for example, theoretically, the city could not only permit an off-site sign to go up on city property in exchange for a very significant reduction in existing off-site signs, on a negotiated basis in a way that made sense and that was actually going to clean up the visual environment. And the city, as the landlord, could also negotiate an agreement where the city would financially benefit from that particular off-site sign. So there would be both a benefit to the visual environment and also a financial benefit. Again, it's a complex issue. We would want to have the staff resources as well as the consultant resources to really tackle that particular issue. Okay, third issue that we think should be addressed, a significant issue going forward, digital displays. Again, we had recommended that before, and the Planning Commission had accepted this recommendation, that digital signs, whether they are off-site or on-site, only be permitted within a sign district. Since our direction was to not include any regulations at this time relative to on-site signage, that is not part of this particular ordinance today. But there is a motion to address on-site digital signage. Technically, any existing sign today could go digital. Many cities that have faced this issue have adopted reasonable regulations as far as the size of these digital signs, spacing, in consideration of the visual impacts of this powerful technology. It could also be, if it's crafted in the right way, another tool for consolidating existing signage, on-site signage, and further reducing visual clutter. Again, it merits further study, public engagement to get at the particular issues, and something that we think should be addressed on a longer-term basis. And then a final main issue I think that Council is certainly going to have to tackle are the settlement agreement signs. These are digital signs that were permitted under settlement agreements that a court found were illegal. And there are over 100 of these digital signs at various places within the city. And it's under appeal, and there might be a ruling one way or the other relative to that particular appeal, and the city is going to have to tackle that particular issue probably sooner rather than later. And we think that this is something that should also be addressed. But it should be addressed in a thoughtful, deliberate manner and through the legislative process, since the courts have said that we can't tackle this particular issue through settlement agreements. Any questions on that point? Okay. All right, so so those are things that we think should be done and should be addressed, but they're not part of this particular ordinance. So let me turn to the policy relative to sign districts. Okay, currently we have 3 sign districts that have been approved in the city. The Hollywood sign district. We also have, not through a sign district per se, but we have LA Live, which is a specific plan that allows a robust off-site signage and digital signs, and the 15th Street one, a very small sign district, and then the recently approved Wilshire Grand sign district in downtown Los Angeles. The main policy question that's before the council is where and under what circumstances should we allow the establishment of sign districts. The first issue is are areas of the city where a process could be initiated, a legislative process with a public hearing going before the Planning Commission with approval by council. Where could a sign district be initiated? Currently, any C or M zone within the city can have a sign district established, and also under current code, any specific plan can authorize off-site signage. So technically, we have a regulatory scheme that would allow every parcel in the city to be permitted to have an off-site sign. So that gets back to the first point, which is, do we want to have a regulatory scheme that would allow essentially an incremental evisceration of the citywide ban so that the exceptions as a whole would swallow up the rule? So what we are proposing is that we limit the areas of the city where you could even contemplate initiating a sign district, and that we would limit them to regional centers, regional commercial areas in the greater downtown area, because these are all areas that have been designated on the general plan as areas where it's most intense future plan development and it makes the most sense. Another major issue has to do with the minimum district size. There's been a lot of controversy about this. Currently, the policy is to allow either a 1 block or a 3 acre size sign district, and we're recommending a larger minimum size of 5,000 linear feet of street frontage or 15 acres. The rationale for this is really twofold, and I think this is where policy issues and legal issues come together. From a policy standpoint, we think that in order for there to be a true district, it has to be a certain minimum size. We think it needs to have a mixture of uses. We think it has to be a destination, a regional attraction, and if it's too small, it just simply doesn't rise to that standard and threshold. From a legal standpoint, if the size of a sign district is too small, you can essentially favor one property owner over another, and that would get us into potential First Amendment trouble by favoring the speech rights of one over another. So we're recommending...
Mr. Bell, can I ask you a question just on
Yes.
that point? Has that ever been challenged or tested, the size limitation on sign districts, either here or elsewhere?
I can't answer that question, but our advice from the city attorney is that even though there's no absolute black or white litmus test as far as what is and what isn't, we think that we would be in stronger legal ground, and also we think it makes sense from a policy standpoint to have a minimum size relative to sign districts. And I have some graphs and tables that kind of set this into context that I'd like to go through. So if we could have the next slide. So this graphic illustrates the areas of the city that are currently eligible for sign district. And again, this is basically almost all the commercial and industrial zoning within the city of LA. Everything in blue and red is eligible for a sign district. And then the rest of the city could be a specific plan. So this gets back to my first point, which is that we have a zoning scheme that would allow every parcel in the city to have an off-site sign, theoretically, through a process. So our recommendation is to radically ratchet that down, and this map shows the areas that we would recommend be eligible for sign districts, and that we would remove the option to have off-site signage or otherwise prohibited signs through a specific plan. And these areas are regional center and regional commercial areas designated on the community plan. The greater downtown area, that's a large red spot in the middle. And then also LAX, International Airport, and then also the Port of Los Angeles. These are areas of international transport and are appropriate areas, we believe, for consideration of sign districts. Again, this would be just the minimum floor for considering sign districts. Every sign district application would have to go through the usual process, notification to the public, findings, environmental review, hearing before the Planning Commission, and then finally council approval. But we think that these are appropriate ground rules and would eliminate the possibility of setting up a zoning scheme that would allow exceptions to swallow up the rule and therefore attack the integrity of the citywide sign code ban.
So what's in purple?
Purple are the Port of LA at the south and LAX on the west.
And these areas that we have on the map that are red and purple would also require council approval as well.
Absolutely. Every one would require council approval. They'd have to be adopted by ordinance and the signature of the mayor. So we would follow the usual process of public hearing. Planning Commission would have to weigh in on that particular issue. And we'd have the notification for within a 500-foot radius of property owners. And we'd have to make very detailed findings, as we are recommending, in terms of whether the sign districts comply with the rules established in the Worldwide Rush, whether they are in fact meet the threshold test for what is truly a district, meaning that it's a regional destination, and it's consistent with the city's policy as set forth in the general plan.
And if it's on the map, it doesn't mean it's automatic.
Absolutely not. There is a very rigorous process for considering every application. There's a hefty application fee if it's to be initiated by private property owners, or the council can also initiate sign district applications.
Thank you.
So the second issue relative to the threshold standards for establishment of a sign district has to do with the minimum size. So I want to show some graphs about this. What we're recommending is that a twofold standard, either 5,000 linear feet of street frontage or 15 acres. Basically, one block is equivalent to about 1,800 linear feet. 3 blocks, city blocks, typical city blocks, is equivalent to, over the standard that we're recommending, 5,400 linear feet. And you can see that this is roughly 3 blocks within the downtown area. Next slide. In terms of, was that it? Okay, this is just another example illustrating the same point. The size of a block, 320 feet by 580 feet, and then 2 blocks, in this particular example, is over 5,000 linear feet of street frontage. This is an example from Hollywood of sign districts. Again, it's approximately 3 blocks, over 5,000 linear feet of street frontage. Another example also from Hollywood. Getting to the other standard, which is acreage. This is illustrating what one block is a little less than 5 acres. 4 blocks would get you over the standard of 17 acres. And this shows what would be within downtown. Again, this is about approximately 3 city blocks in Hollywood, over 16 acres. I think this particular graphic really illustrates it for comparison purposes. This is our proposed minimum for street frontage, but compare that to the LA Live and the Convention Center, which are essentially have the same defining characteristics and the same types of signage. That's 19,000 linear feet of street frontage, and then Hollywood is over 26,000. So we think our recommendation is very reasonable in comparison to these districts. And in the same comparison relative to acreage, our proposed minimum is 15, and then compare that to the LA Live area, and then Hollywood, 89 acres in the LA Live area, and then 400 within the Hollywood sign district. So overall, we think these are reasonable standards for consideration, both from a policy standpoint and a legal standpoint, as a baseline rules for establishment of sign districts. Okay, another main issue that is, I think, a key core policy of the rules relative to sign districts has to do with sign reduction. This gets back to the standard that the courts had outlined, that in order to grant an exception from the citywide ban, there has to be a corresponding improvement or benefit to the city's visual environment. And this is consistent with the Planning Commission's action from 2 years ago, and also Plum, that the best way to meet that test and to gain a measurable, quantifiable benefit is to require that there be a minimum greater than 1-for-1 reduction of existing sign, either within the sign district or within a sign impact area. Basically, our recommendation is that to not allow a sign code that would allow for a proliferation of signs over and above what we have right now, but that we use these tools to whittle down the existing inventory of off-site signs. So we think that because of the Business and Professions Code limitation on when we can require takedown, that we not give up this particular tool. Many stakeholders have recommended that we have a different standard, either including sign reduction or some kind of community beautification standard. In the discussions, we felt it was very difficult to quantify that, very difficult to measure that, and oftentimes those kinds of community benefits for major projects, we would be getting those anyway, so how would we know that the benefit was due to the sign going up versus a development agreement that we would negotiate that benefit regardless? The only exception to this particular sign reduction provision that we would recommend, because it's very narrow and has a very narrow purpose, are for National Register Historic Districts. We have 2 of those within downtown that a sign reduction requirement not be conditioned for a sign district so long as the signs within National Historic Districts, if they are off-site signs, comply with the Secretary of the Interior standards for rehabilitation, and that any sign rights not be granted until the rehabilitation of the historic building has been completed, and we have included that language in the pass-out that we granted today. So we think that that is the only exception that we think has merit, but on an overall basis as a policy, we believe that a mandatory sign reduction to reduce the existing inventory of off-site signs is a very powerful tool for cleaning up and improving our visual environment. And I want to talk about the relief mechanisms. I had mentioned before that this particular ordinance includes 3 different ways from varying from the citywide sign code, and it includes different reasonable limitations on the exercise of that discretion so that we don't get ourselves into the kind of legal hot water that we had before. Currently, the only process for considering relief from the citywide baseline sign standards, and I'm talking about the commercial identification sign, is a variance process. And there's no limit to what you can request. Technically, you can ask for a variance that would result in a doubling, a tripling, a quadrupling of the amount of sign area. There's no legislative cap on what you can ask for, and the findings themselves need to be updated to reflect recent court rulings. So our recommendation relative to the variance procedure is to split it up into 3 different discrete kinds of tools. The one is the sign adjustment, which is similar to the existing procedure we have currently within our code for considering minor deviations from the code. This would allow a cap of a 20% maximum deviation from the height of a sign and the area of the sign. The second would be the sign variance, and we would have the existing procedures for your usual variances, but cap it at no more than the combined sign area allowed on a site, but flexibility in terms of where that sign area could be located. And then the third major provision is a sign program, and I want to spend a little bit of time talking about the sign program recommendations. And that would be the third tier of this sign relief scheme that we are recommending. This is substantially the same as what the Commission had recommended and Plum had weighed in on 2 years ago with a few changes. We would recommend that the minimum size eligible to file for a sign program would be within downtown and within regional centers. It would be 50,000 square feet of non-residential floor area, or 5 acres, or 3 acres, excuse me. And outside it'd be 100,000 square feet. A sign program is a kind of an innovative tool. It's really intended to allow flexible sign regulations for museums, college campuses, sporting and cultural institutions, where there's a justifiable need, given the nature of the site and the nature of the use, for considering deviations from the citywide code. It doesn't just quite fit. And we want to have a process for considering those kinds of requests. So we would recommend that we still cap the consideration of this at the combined sign area limits that we have currently in the code, have a legislative process that would go before the Planning Commission, notification to the neighbors. We would also recommend that a limited number of off-site signs be allowed through a sign program procedure, a maximum of 10%, to provide flexibility to enable sponsorship or donorship kinds of signs, with the caveat that these signs, unlike in a sign district, would not be visible from the public right-of-way or from adjacent properties.
So, Mr. Bell, if I was playing devil's advocate, I would be saying, here we go. We did all this articulation. We broke down all these different rules and regulations, but now we've given them a way out. And now we have, after going through all this, they're still going to get what they want. And what I hear you saying in response to that is each one of these provisions in of themselves have a process where the stakeholders will also participate and will also go through the decision-making process. Even though they do exist, they have specific measures to have stakeholders participate on the end result. Would that be accurate?
That's accurate, and it's actually, there are requirements for more engagement. What I think is distinct from what we're recommending is to cap legislatively what can be put on the table and considered as a deviation. Currently, there is no cap with a sign variance or a variance procedure. You can ask for the moon. What this would do is it would establish very reasonable limits to provide flexibility, to strike that balancing act, which we always try to do with these kinds of zoning regulations, to enable a thoughtful, deliberate process, because in a city the size of LA and with the diversity of LA, we do need to have procedures in place to consider those exceptional circumstances. And
but on top of that, we have to be consistent with the legal rulings.
Absolutely.
The legalities are such that what got us into hot water last time is that we were being viewed as being inconsistent, that we did not have enough regulation, we were doing it in a manner that the judge felt there was no real discretion. It was just happening because of whatever reasons they came up with.
Correct, and all of these procedures, we work very closely with the city attorney's office to include findings that the courts have found to be the proper way to evaluate these kinds of requests. So that's a very important feature of what we're recommending. The findings have been strengthened. They are more objective criteria for evaluating whether or not an exception should be granted in the first place. So just, I'm almost finished. I know this is a lengthy presentation, but I think it's important to get out these particular kinds of details.
Get it out of the system, right?
Yeah.
All right, go for it.
Okay, civil penalties. Enforcement was one of the issues that the committee had identified as being of critical importance, and that we don't have an effective means right now for enforcing our citywide code, in particular our ban on off-site signs and super graphics. So we have recommended very steep penalties, administrative civil penalties, to strengthen our ability to enforce those sign regulations. What we had recommended before and what the Commission had adopted and Plum had adopted 2 years ago was the same steep penalty for on-site signs as well as for off-site signs, and we would recommend not to do that. We think that violations of the off-site sign ban are really the most egregious violations. They're the ones that have the most significant impact on the visual environment, and these are the kinds of signs that generate revenue for property owners, significant windfall profits for property owners and for sign owners, whereas business identification signs are not in the same ballpark as those kinds of signs. They do not generate revenue, and they are necessary for business identification purposes and for businesses to be able to attract customers. So we would recommend for violations of the on-site sign code that they just be subject to the same penalties as any other violation of the municipal code, which is $2,500 a day, but that we retain very steep provisions for violations of the prohibited signs that do generate a huge revenue for sign companies and property owners, and those are the prohibited digital signs and super graphics and other kinds of off-site signs. So the core of those recommendations are retained within this particular ordinance. Also want to talk a little bit about digital displays. We're recommending, again, because we think that this is a glaring omission within our sign code for digital signs. This technology is being used more and more, that we have 3 standards, minimum standards, pending a future robust, comprehensive update for digital signs. 3 standards really relating to the brightness of these signs, the message duration, when one sign shifts to another, and then a message transition. So we have 3 standards that we're recommending as a minimum for digital displays. And then other key provisions of the ordinance, we would recommend, because we are codifying these standards on digital signs, that we remove the hazard to traffic procedure, which is a very cumbersome administrative procedure. Just simply enabled the Department of Transportation to require compliance with these standards that they would recommend anyway. So we recommend just codifying those standards and eliminating this duplicative procedure. And then also we would recommend removing the right of private action, which we think would just simply embroil the city in costly litigation and wouldn't be advantageous as far as enforcement. We think that the most advantageous would be the civil penalties. Next slide. A couple of other suggestions. We're recommending changing the definition of an on-site sign to match the definition within the Business and Professions Code at the state level. Our current definition is confusing and hard to interpret, so we recommend using what the state code defines. And then, as I had mentioned before, the on-site sign regulations, pursuant to the direction from Plum, this ordinance does not include any of those changes to that, pending the implementation of a sign code administration program. All right, I'm going to take a pause. One other final. There's more to come. Application fees for the different kinds of processes that we have outlined. These are within the packet, but we are, based upon an internal study, we're recommending basically a tripling of the application fee for a sign program to over $30,000. That's based upon our best judgment of how much staff time it would take on a full cost recovery basis to process an application for this kind of sign program. So that is in the amending packet that we distributed this afternoon. Okay, grandfathering provisions. One of the principles that we think should be adopted in going forward is to not cause a hardship for those applications for specific plans and for sign districts that have been in the process for quite some time, to allow them to continue to be processed to the end under the rules applicable as of today, and not subjecting to the new rules going forward. I mean, this is a typical and usual principle in adopting these kinds of foundational zoning regulations, so we would recommend grandfathering rules, and that's consistent with the action that Plum took a couple of years ago. One of the, Tana Blackman will be providing a list of which projects would precisely benefit from those grandfathering rules, and that is part of the package that we just passed out, and that we will be posting on our website this week, so the public will have access to that particular information.
Can I ask a question, Mr. Chair? When you use the term initiated or applied, is that a term of art that you use in planning, or is there a difference between initiated and applied?
Initiated would be initiated by either the City Council through a motion, the Director of Planning, or the City Planning Commission. They have the authority to initiate, and then applied for would be through a private applicant. Okay. We're taking a rather expansive definition of initiated or applied for to also include projects where environmental review process has begun and that environmental review process has identified a specific signage program as part of the review of that development project.
Got it. So applied, I mean, I think that is a bit more easier to determine whether something's been applied for or not. Once we initiate it, it's either through council motion or what other way?
Director of Planning
Planning,
City Planning Commission can technically initiate land use ordinances.
Okay.
And then
you gave us a list of both, right? The initiated or applied.
that's a comprehensive list,
Okay.
and we can run through that list. Is it on the slideshow? I'm going to turn it over to Tanner Blackman, who's going to run through the list.
Okay, thanks.
Tanner Blackman, Department of City Planning. Basically what I was doing is taking section 13 on page 40 of the draft ordinance and looking at the language before you today, what that language would grandfather, so which projects would benefit from these provisions. And how we've done it is that these first ones, the first 5 on this list, were applications from like 2007 or 2008 for sign districts that were frozen in the process while there was pending litigation. So things that had applied years ago, and even part of it may have been already approved, but we were waiting to make a decision on the sign district provisions. Those are the Metro Universal project, not the big specific plan for Metro, but the one above the actual Metro station at Universal. The Metropolis project downtown, what's known as Midtown Crossing, kind of mid-city. The Figaro and Olympic, which is the Hanover Tower and a FITM building block downtown, and the Seaward addition, the Seaward project addition to the Hollywood sign district. Those 5, and this is detailed on the sheet, have been in the works since like 2007, 2008. The next 2, the City West Supplemental Use District and Koreatown Supplemental Use District, those also are years old in terms of the council motion that initiated those. And then the Figaro Corridor SUD is a more recent council motion. Those 3 are all pending sign districts that were frozen in time while we were figuring all this out. In addition, there are specific plans that had, as Alan explained, different sign regulations than the citywide standards. The way that those are going to be processed moving forward is that they'll still be able to benefit from the sort of grandfathering provisions, but the signage portion of those applications will be taken out and processed as an SUD. So these will be sort of a specific plan and SUD moving forward. And I actually think I got Los Angeles International Airport on the wrong list here. I think that was actually recently filed as a signed district. But there's the Convention Center and Farmers Field specific plan, the USC specific plan, the Boyle Heights Wyvernwood project, and NBC Universal Evolution specific plan, and also the Warner Center specific plan that's currently being revised, all of which would benefit from the grandfathering provisions as written in the draft before you today. There's a chance there could be a couple more out there. This is the best from scouring everything that's been applied for in the last several years that I was able to come up with that would benefit from these provisions. And I'm going to have Daisy come up for one last thing, which she'll explain.
When you say there might be other ones out there, you're not going to leave us in suspense, right? We're going to find out sooner or later?
I'm scouring. I'm pretty sure it's just these 14, but the final wording is the final wording that will be adopted, and that's what will be adopted.
Okay, the clearer the better. Thanks.
Good afternoon. I'm Daisy Moe with the Planning Department. There's just one small list of things that we want to go over before we open it up for questions in general. And you have before you a list of additional recommended changes. Since we published the draft ordinance a couple weeks ago, we've gotten a whole lot of feedback. There have been a number of relatively minor changes that we could make without doing further study that we're recommending be included in the proposed ordinance at this time. And this list is also going to be published on our website this week. So a brief summary of those changes is a number of technical changes proposed by the Department of Building and Safety to increase clarity and enforceability. Clarification of the provisions regarding the transferability of credits for the removal of existing off-site signs. Adding a very narrow exception from the sign reduction requirement for off-site signs used to incentivize blight reduction within a National Register Historic District. Ensuring that our definition of an on-site sign conforms closely with the state definition. In some cases, allowing wall signs over building openings only when the fire department determines that the sign would not create a hazardous condition. Allowing comprehensive sign programs within overlay areas, but not within sign districts or specific plans. A few clarifications of the rules pertaining to grandfathering. And finally, a revision of the application fee for a comprehensive sign program based on a relook of the processing time and labor costs.
Great. I don't have any questions, but I do have compliments. I want to thank Alan and yourself, Daisy and Tanner. Again, you guys been consistent and prioritizing to get us to this place. I know we have a little bit more to go. I think this is the beginning of still other very robust dialogue and discussions, but you got us on a track that I think we can work with, and we waited 10 years for this, so we got to make the best of it. So thank you, Daisy, for your hard work. And I know the city attorney's also working very hard too, but we'll do the compliments after this discussion. So that being said, do you have anything else to add, Mr. City Attorney, Mr. Fong?
I've been working on the sign litigation for the last 10 years, so.
That's right, that's right.
I know firsthand.
I feel your pain. Okay, folks, we have a hefty stack here. If even with the 2 minutes complete, we'd probably be here for about maybe 2.5 hours. So, I know you guys are tired. I know we are. But this is an important issue. So what we'll do is we'll go with 1 minute, and if you need more time, we'll have that flexibility. But I'd like to get to you guys sooner than later. And so we're not here till 6, 7 o'clock. So that being said, we'll move forward and give us your name and address. If you have a letter with you, you just get to the points of the letter so you don't get caught up in introductions in the body and you weren't able to make your point. So that some of you have worked on elaborate letters, and we'd like to hear what you need to say. And if someone already said what you had to say, it's okay to say, I agree with the previous speaker, and give us more information and or different information. But to hear the same thing over and over again, we kind of like, okay, let's keep going, folks. So that being said, let's get started. Are we ready? Our first speaker is Connie Elliott. Then we have, I believe it's L-E-I-L-I, and Lily Igbo. And then we'll have Veronica Perez. Good afternoon, ma'am.
You want my full address? Connie Elliott, 4061 Cartwright Avenue, Studio City, California, 91604. I'm representing the Studio City Residents Association, which represents 1,400 member households, and we are opposed to off-site signage in city parks. This would set a precedent that would be difficult to rescind. Your document calls this revenue generation idea innovative. We would not agree to an adjective that is so positive about this bad idea. The city holds a public trust in the control and operation of parks and open spaces, and defacing them with billboards and advertising is a violation of that public trust. My neighborhood is also very near Universal Studios, which is trying to get a sign district. Studio City doesn't want to be New York City. Calling it a sign district doesn't make it any more agreeable. We don't want digital billboards near our homes, much less visible from our homes, and we wish to relax in our parks, Campo de Cahuenga, and zoo without being subjected to advertising. Thank you.
Thank you, ma'am. Next speaker.
Mr. Chair, can I ask the Planning Department first to clarify the parks issue and what language is in this ordinance pertaining to parks, so that as future speakers come up, we could be clear what is and it is not in there. Thank you. Yeah.
You were asking me a question?
No.
Planning Department to clarify any language in the ordinance pertaining pertaining to parks.
Yes, Alan Bowe, Planning Department. I mean, one of the mechanisms that we had outlined within the draft ordinance is something called a comprehensive sign program, and that would be available through a public process for city parks, as we see it, as well as other qualifying types of uses. It was intended to allow flexibility in the sign regulations for museums, cultural institutions, sporting facilities, college campuses, and similar types of uses, multi-tenant malls, for example, where they don't quite fit and they have different signage needs. Again, consistent with the idea that we want to have reasonable limitations on these kinds of procedures, what we had proposed is that the total signage that would be allowed within the sign program could not exceed what you can get today on a citywide basis, but that there be flexibility in terms of where that signage can be located. And that does two things. It does provide that flexibility, but it caps the total signage so that you don't have super graphics or other kinds of outsized signs that would be inappropriate. Just as a technical clarification, the amount of signage that you get is based upon the length of the street frontage, and it's basically a ratio of 4:1. So you would get around 4 square feet of sign area for every 1 foot of street frontage, and you can only use it along that frontage. This would allow consideration to transfer sign rights from one street to another street, but the total on the site couldn't exceed 4:1. And then the second, hopefully that's clear. Yeah. And then the second piece of it would be this off-site sign provision. Again, the total off-site signs couldn't exceed the total allowed for that site, on-site as well as off-site, and no more than 10% of the signs could be display off-site advertising, and none of those signs could be visible from an adjacent property or from a public right-of-way.
And as it pertains to parks, there's no enabling language in the ordinance that will allow for signage to be put up on parks.
Not today.
Not today.
But this proposal would allow that.
The proposal will.
Yes.
And I thought the language was to explore it, that it wasn't in there already.
These modifications would allow, on a case-by-case basis, consideration within those limitations that I've just outlined.
Okay, I thought it was just a direction to continue the exploration of the possibility for possible revenue for the city, but I didn't realize there was language in there, so that's one item that I need to look at more intently before it comes back to us. Okay.
And again, this gets, I think, to the vagaries of the sign regulations. We couldn't call out the kinds of uses where we think it's appropriate, like malls, like college campuses, and then say they could file for it, but the parks could not file for it. So as long as they met the basic threshold criteria, again, because of the First Amendment issues, we feel that it has to be a process that would be available to anyone meeting those minimum standards that we are identifying, whether it's a city facility or it's a private property owner. So that, I think, is part of the consideration. If we were going to remove it for parks, we'd have to remove it for any other owner.
I got that issue. It needs just further exploration. I think, at least, I know all the council members on this committee must have received a number of emails and correspondence on the parks issue, and at least the response I got right now, I think it needs further exploration. And I know we are not deciding today, but it's good to hear from the stakeholders on this issue and to further examine. To further examine if it makes sense or not. So
Councilman Kukorian? Thank you, Councilman.
Yeah, I'm sorry to disrupt the flow of public comment here, but I'm trying to understand this point about not being able to draw a distinction under First Amendment analysis between park use and nonprofit or commercial facilities that have a comprehensive sign program. That doesn't make any sense to me at all, actually. I mean, I think that once we open up public areas for commercial speech, then you run a major First Amendment issue about it becoming a public forum.
Right.
And then you wouldn't be able to regulate content. But when there's no regulation of content, can't you simply say that public property is not appropriate for a comprehensive sign program, and a comprehensive sign program that meets all these other standards you've described might be appropriate in the sporting facility and those other things, but can't you simply define it as excluding park space, public park space? I don't understand why that raises a First Amendment issue. Maybe the city attorney could comment on that, because I'm not sure how that implicates the First Amendment.
Well, City Attorney Ken Fong here. There are a lot of complex issues here and some I'm not really at liberty to discuss, but I'll just point out a few that I think might help you think about this process. When it comes to parks, the councilman is correct that a traditional park is one of the traditional public forums. Now, there are a lot of cases that discuss various public venues where part of it is a public forum and part of it is not. For instance, in airports where people gather, that's a public forum, but there may be certain venues for signage where the city operates those in a proprietary capacity. So the city would be able to control signage, for example, on a big advertising placard in a bus station or an airport. So we have to look at those on a case-by-case basis. And I think what Alan was referring to when it comes to the comprehensive sign program, he is saying that is enabling legislation, and it would potentially be possible for an application to be made to have signage in a park, but then the City Planning Commission and the City Council would have to look at that proposal to see if it's appropriate, and I would imagine that it would not be appropriate to have signage in every square inch of the park. You'd have to look at that individual proposal, and the planning staff would also have to analyze it. And you're right, there would be other issues involved as well.
And again, not to belabor the issue, I apologize, but or you could have enabling legislation that treated them the same, but you could have a separate city policy that said it is the policy of the city that we will not pursue comprehensive sign programs in the public parks, couldn't you?
Yes, certainly. I mean, there's a lot of flexibility. You know, I've advised the City Council on the Worldwide Rush decision and other decisions, and there is now a lot of flexibility in how cities draft their sign regulations. And legislatively, if you decided that you did not want to have any signage in parks, that would be the prerogative of the City Council.
Okay. Thank you. I'm sorry to take us
No
off
problem.
track.
And it also begs the question, the role of, based on the charter and how it's structured, how much discretion the council has in the context of the park commissioners, because I know that's something that Councilman Labange has brought up in the past. And so I think that we're still got to go through that analysis as well.
Yes, exactly.
Okay. Okay, thank you, Mr. Moore. All right, folks.
Good afternoon. My name is Layli Egbal. I'm an officer at Zivest Holdings, 611 Wilshire Boulevard. I'm here today to talk about the temporary sign component of the ordinance. As somebody who's obtained many temporary... As someone who's obtained many temporary signs for my buildings, the process has been extremely exasperating and very expensive, and I feel like it's time for perhaps a new model for the temporary sign component of the ordinance, and perhaps that's an annual permit fee that a building can obtain where they pay based on their square footage, and the signs that they put up are interchangeable throughout the year so that there's no need to obtain new permits every time a new sign goes up.
Thank you, ma'am.
Thank you.
Veronica Perez.
Good afternoon, Veronica Perez with Holland and Knight, representing the California Sign Association. Thank you so much, Councilman Reyes and council members on the Plum Committee, for your leadership in protecting on-site business signs. We would also like to thank the Planning Department, in particular Alan Bell and Daisy Moe, for their tremendous work on this. They have been fantastic about stakeholder outreach and being responsive to our concerns, and we appreciate that very much. Overall, we're very pleased with the draft, and we want to move forward with adoption. We just have a few outstanding issues. The proposed minimum area for sign districts, we believe, is excessive. Currently, 1 block or 3 acres is required. Planning's proposal is a 5-fold increase up to 15 acres. This change is unnecessary and we believe ties the hands of our decision makers to decide our council members to decide what is best for their own district. It's already very difficult to establish a sign district. The fees, $140,000 plus, multiple stages of review. This could not be a worse time to take away options from our decision makers, and the sign district provisions do just that. Thank you.
Thank you very much. And if you could also allow the clerk a copy of your presentation, that we can keep your notes intact as well. We have with us Howard Sunken, Mitch Chemers, and Ken Persons. And then we'll have Stan Sosa.
Good afternoon, Mr. Chairman, members. Howard Sunken, Senior Vice President of the Dodgers. We were here about 2.5 years ago having this discussion regarding the signs at Dodger Stadium and our scoreboards, and I thought we came to a conclusion that day that language would be included to protect the modification of those signs, but something happened in the last 2.5 years. I had a conversation with Mr. Bell before the hearing. He said we'll work together to try to resolve that, and I'm hoping that this committee will support us in that endeavor. Thank you.
Thank you, Mr. Sunken.
Mitch Chemers. I'm here on behalf of the California Sign Association, 6154 Lamona Avenue, Van Nuys, California. I want to point out that I'm a local business owner. I help small businesses throughout the city get permits on behalf of those businesses and local contractors. I'd like to reinforce Veronica's statements about how, the great work you guys have done, and especially planning, getting educated on all the facts. One issue that I would like to point out is in the 3-tiered system, there is a new language about the sign adjustment. The sign adjustment cost, that particular tool we think is prohibitively expensive, and we really expected to see something a little more in line with what we do at Building and Safety that gives smaller issues the opportunity to be worked out. We think this is sort of a sledgehammer solution to a thumbnail problem. It may work great for larger developments and big projects, but we're hoping we can revisit that particular issue because we have a lot of small businesses that need common sense solutions. Thank you.
Good afternoon.
Afternoon. My name is Ken Person. I'm representing the California Sign Association. I would like to thank Councilman Reyes, the Plum Committee, and planning staff for your leadership in protecting on-site signage. I would like to focus on the issue of on-site electronic signs. The most cost-effective form of advertising for businesses is on-site signage. On-site signs, electronic signs, can increase business revenues by up to 150%, having tremendous benefits to the city in terms of tax revenue and jobs. The draft ordinance before you contains appropriate protections for neighborhoods, including brightness limitations, minimum time durations, and regulations for changing messages. After much deliberation, Plum instructed planning to leave on-site signs alone, and the draft before you allows on-site electronic signs with the appropriate restrictions. Some have called for a moratorium on these signs. We strongly oppose any such moratorium. Such a prohibition is unnecessary and would take yet another valuable tool out of the toolbox in helping Los Angeles stay afloat during a time of record unemployment. Thank you.
Thank you, sir. Good afternoon.
Good afternoon. Stan Sosa, 4126 Seaview Drive, and I'm here to represent our families, about 50 of them, at Art in the Park, Herman Park, and the Mount Washington Homeowners Alliance. And basically, we don't want our children and families to be marketing targets while they're enjoying the nice recreational open spaces and recreational facilities that are in place now. And finally, I think I want to say that we oppose any signage, commercial signage on our parks. Thank you.
Thank you. Bernadette Soder, Jennifer Mallory, and Donald Seligman. Good afternoon.
Good afternoon. My name is Bernadette Soder, and I'm Vice President of Outreach with Friends of Griffith Park. Friends of Griffith Park is concerned about any new provisions that could allow the introduction of off-site signs to parks under their classification as city-owned properties. Remember, the greatest concentration of city-owned property in our metropolis is in our more than 400 parks. We oppose introducing commercial advertising in them as billboards and on surfaces such as shade structures, walls, paths, and furnitures. Because we believe parks should be refuges from commercialization, we staunchly oppose the establishment of comprehensive sign programs within them. Previously, comprehensive sign programs have been limited to heavily urbanized areas of the city so that, we were told, the rest of our metropolis could be free from blight. Now the very definition of comprehensive sign district may morph to include the least urbanized areas of our city, our parks. Please don't allow this to happen. Let me close by expressing my appreciation for your sensitive questions and comments on this issue. Thank you very much, council members.
Thank you, ma'am. Good afternoon.
Good afternoon. Jennifer Mallory with the Pacific Palisades Community Council. We've submitted a letter. We very much appreciate the opportunity to work with planning, particularly Alan and Daisy. We have 7 points of opposition to the ordinances drafted. I reiterate that we oppose signs in the park through use of the comprehensive sign program. 2 of our other key points relate to what we call the interior sign exception, which is in section 14.4.3 subsection A. In the Palisades, we're concerned, our catchphrase is unintended consequences, that this is a way to allow commercial on-site, as a way to allow off-site and temporary signage in areas of the Palisades, our private schools, our park that has walled baseball fields. We have buildings with atriums, and as the ordinance is currently written, that interior sign exception is a total ban. We've submitted 3 suggestions to planning for how it is we'd like to see the ordinance modified. The last point I'm going to address is the regulation of digital displays. We feel that it is grossly inadequate. We have questions relative to Article 4, Section 14.4, subsection F, which has something called a sign illumination limit. It's not clear how that limit applies to the interior sign exception that I just quoted, and also our main point of objection here is that there's no ability to regulate light spillover. Thank you so much.
Thank you, ma'am. Donald Seligman, and then we have Lucinda Stewart, and then Mark Phillips.
My name is Don Seligman. I live in Los Feliz, and I thank you very much for giving me the opportunity to speak to you. I am the current president of the Los Feliz Improvement Association, and I speak on behalf of thousands of Los Feliz residents who are members of our association. As the neighborhood most closely associated with Griffith Park, we are strongly opposed to commercial billboards and off-site signage in Griffith Park. We are concerned that the currently considered amendments to the recent sign ordinances would open up Griffith Park to commercial signage by allowing installation of off-site signage on city-owned properties, which could include Griffith Park. Furthermore, the new restriction for sign districts to areas defined as regional centers might be construed to include Griffith Park, which is a focal point of major entertainment and cultural facilities. Our thousands of members are adamant that any new sign ordinance amendments specifically exclude city parks from sign districts and that billboards and commercial off-site signage remain prohibited in the parks, including Griffith Park. Thank you very much.
Thank you, sir. Good afternoon.
Good afternoon, council members. I'm Cindy Starrett from Latham & Watkins. Chairman Reyes, we very much appreciate your leadership on development reform, and the city has embarked on a great program in that regard. We know all 3 of you are very committed to jobs and economic development, and the reason you see so many people here from the business community, you'll hear from the LA Chamber and from VICA, is that signage basically means someone is setting up a business in the city of Los Angeles. That business is trying to advertise so customers can pay sales tax, which will go into the coffers of the city of Los Angeles. I know you're all committed to balance, and I think staff has worked very hard over the past 2.5 years to establish that balance, but the issues that that the community is bringing forward today and that the sign industry and that businesses are bringing forward today represent those last critical changes to be made as soon as possible so we have certainty for that investment. Interior signs for Dodger Stadium, for Loyola Marymount University, for shopping centers like Westfield shopping centers, interior signs are a critical issue because they don't impact public safety, they don't impact the aesthetic of the public street, but they allow businesses to do business, they allow entertainment venues to entertain their customers, and so we ask that you do support the interior signs, and then we propose language which is consistent with what you did for LMU, saying that those signs need not be primarily visible from the street.
Thank you very much.
So thank you very much.
Okay. Good afternoon, ma'am.
Good afternoon. My name is Lucinda Phillips. I'm a board member of Friends of Griffith Park and Parks representative for Hollywood United Neighborhood Council. We are opposed to the proposed new sign ordinance permitting commercial signs in parks. This will result in extensive advertising in large parks like Griffith Park and others, and providing unprecedented marketing access to children and families. Parks are not advertising venues, nor should our children and families be marketing targets in the parks. Thank you.
Thank you, ma'am.
Good afternoon. I'm Mark Phillips with Brookfield Properties, 601 South Figueroa. Brookfield owns major high-rises downtown as well as the Figuette 7th shopping center that's undergoing renovations. There's been some significant improvements to this ordinance since we last were here talking about it, and we just have a few minor issues to raise. In particular in the comprehensive sign program area, because we think this is the kind of thing that will apply to our properties. First, we would like to see the section 14.4.5 of the ordinance that concerns freeway exposure to be another one of those that are in the long list of sections that the comprehensive sign program can vary from. There's a 2,000-foot limitation otherwise, and there's a lot of projects that downtown, which are almost half of downtown probably, is 2,000 feet within the freeway. Also, we're concerned that the courtyard exclusion is inapplicable when you've got buildings surrounded by high-rises, and that those are two major concerns.
Thank you, sir. Our next set of speakers, we have Leanne Muller, John Duong, John Massoni, and Patricia Gallery. You can form a line, that's great. Good afternoon, ma'am.
Good afternoon. My biggest challenge will be able to read this without the glasses and too much distance. My name is Leanne Muller. I am the division president for Southern California for Clear Channel Outdoor. My address is 19320 Harbor Gateway, Los Angeles, 90501. Here to just tell you that Clear Channel has been a part of this community for almost 100 years, and since we opened our doors, we have worked very closely with the city, with law enforcement, with nonprofits and public service groups to benefit the greater community. We routinely partner with the City of Los Angeles and have recently, in the last year, worked on programs such as the Grim Sleeper, Carmageddon, the Domestic Violence Prevention Program, and graffiti issues. Digital billboards are an important part of our business and also an important part of the community because they not only provide a voice for local business, but they absolutely serve the community with the ability to reach out to the public for emergency preparedness, emergency response, and emergency recovery. We welcome the opportunity to work with the City Council to structure an ordinance that will benefit all the stakeholders.
Thank you, ma'am.
Thank you.
And just for the audience, we're not going to accept any more speaker cards because we'll stay here. Who knows who wins. So we're going to cut it off. If you submit a card, we'll have it for the record. But I'm hoping we got it almost to everybody already. Mr. Duong.
Chairman Reyes and honorable members of the committee, thank you for the opportunity to address this body and speak on this important issue. My name is John Duong. I'm Clear Channel Outdoors Vice President of Real Estate and Public Affairs. I'd like to point out that city staff, in particular Alan Bell and Daisy Moe, have been pleasant to work with, and we appreciate their effort and diligent work in coming up with this consensus ordinance. However, due to budget constraints and reduce in staff, the proposed ordinance falls short of addressing some of the more complex issues affecting the outdoor advertising industry. Amongst these issues not covered in the ordinance are including reduction, relocation, re-permitting, as well as those signs resulting from the prior signage agreement with the city and the outdoor advertising industry. Our company, as well as our colleagues in the industry, are willing to sit down and work with the city toward a proposal that would address these and many other outstanding issues not currently covered under the proposed ordinance. We're willing to sit down to discuss a comprehensive ordinance that can be crafted and meet the needs of the industry, as well as to serve the public interest. In order for this to move forward, the city needs to act now and move expeditiously, and we support that effort, as well as funding the staff's ability to do so. We also have written comments to submit to your.
Thank you, sir. Good afternoon.
How are you, Mr. Chairman? My name is John Massoni. I'm the president of Van Wagner Outdoors West Coast Operations. We're a privately held out-of-home company based in Studio City, California. I'm here to talk about digital disparity and swaps. Years ago, the way the out-of-home business worked is the out-of-home companies would pay a landlord, say, $5,000 and generate $20,000 for a billboard. Years later, because these companies own the permits, my company included, we'd pay $8,000 and generate $90,000. There was a lawsuit a number of years ago where out-of-home companies sued the city over the increase of inspection fees. Van Wagner did not sue. We are very good corporate citizens and have an excellent reputation nationally. Eventually, the city entered into an agreement with those companies that sued the city, which allowed them to convert up to 25% of their inventory to either modernize them or go to digital. The rates today, those $90,000 billboards are charging right now over $1 million per location. We simply want a level playing field. In 2010, we estimate there was over $40 million generated on digital billboards taken out of the static market. We followed the rules. We are suffering because of it. Swaps, which is right now, in addition to the digital issue.
I'm going to need you to conclude, and you can submit your comments in writing. Please finish.
Mr. Chairman, we're looking for a level playing field. We've always played by the rules, and we're suffering because of it.
Thank you, sir. Thank you very much. Patricia Gallery and Marion Dodge.
Thank you. My name is Patricia Gallery. I live at 1946 Mitchell Traina in Silver Lake, and I just want to echo the sentiments that we've heard from other folks here regarding off-site signage in the national parks, in our city parks. I'm a frequent and regular visitor of the Griffith Park area, and I truly believe that these are precious natural areas that must be protected. Thank you.
Thank you, ma'am. Barry Johnson, Dan Silver, and Ann Williams.
Hi, Barry Johnson, committee member of the Studio City Neighborhood Council's Government Affairs Committee. You got a copy of the motion from our board against any kind of commercial advertising in the city parks. I think there needs to be a provision in this ordinance that absolutely positively takes city parks and museums within city parks, zoos within city parks, out of the equation. No amount of revenue the city could generate is worth desecrating our parks. People go to these parks to get away from the hustle and bustle and billboards of our city, and it's the last place you go to want to see an ad. So I think you need something that absolutely positively takes parks out of the equation for this. Thank you.
Thank you, sir. Good afternoon.
I'm Marion Dodge. I'm president of the Federation of Hillside and Canyon Associations, representing 32 organizations spanning the Santa Monica Mountains. The Federation cannot support the sign ordinance as it is currently written. While the City of Los Angeles needs a sign ordinance to regulate the proliferation of billboards throughout the city, this version of the ordinance has been substantially altered since it was approved by the City Planning Commission. The new comprehensive sign program is sufficiently vague to allow signs to be added anywhere. The Hillside Federation unanimously opposed the placement of advertising in city parks. In a world saturated with advertising, city parks represent a refuge from the onslaught of advertising blight. Our parks are full of children, and children are particularly vulnerable to advertising. There's one group of children for whom an ad-free park is critically important, those with ADHD or ADD. City parks with green spaces unobstructed by advertising are a place where they can go and not be overstimulated. This ordinance needs to be amended to specifically prohibit signs in city parks. Thank you.
Thank you very much. We have Ann Williams, Ray Baker, and Al Mogia. Good afternoon, sir.
Good afternoon, Chairman, committee members. I'm Dan Silver, a lifelong resident of the city and Executive Director, Endangered Habitats League, Southern California's only regional conservation group. Why are we here? First, digital signs are enormous energy hogs. They're completely irresponsible from a greenhouse gas standpoint. Secondly, the quality of the urban environment is critical from a regional planning perspective. And we absolutely reject the notion that commercialization and the blighting of our most important commercial areas somehow improves the quality of life. It's the opposite. The thing I want to focus on is this long list of grandfathered projects, specific plans, and sign districts. Looking at that list, it seems to me that it eviscerates the intent of your effort. And I think you need to seriously look at this long list of grandfathered projects. So, in our view, advertising is not life. Look at a vibrant city like Vancouver. They don't have any off-site signage. Thank you.
Thank you very much.
Good afternoon, council members. I'm Ann Williams with the Central City Association. On behalf of our membership, I want to thank the Planning Department for their great work and outreach on this very complicated issue. Several of our concerns have already been addressed in the latest draft ordinance. However, some important ones remain. First, we feel that the proposed minimum size of the SUDs is too large. A minimum of 15 acres is particularly limiting in a dense area such as downtown, where development tends to go up rather than out. The city's policy is that the standard size for most SUDs is 3 acres, and we feel that signage SUDs should not be treated differently than other SUDs. Second, we feel that the draft ordinance is overly restrictive in limiting the possible sites for SUDs, and finally, we're concerned that the rules governing temporary on-site signs, for example, that read "the space for lease," are unnecessarily onerous. The ability to notify the public about the availability of space for sale or lease is a very basic business tool, and requiring these signs to be taken down after 30 days is very burdensome. Thank you.
Thank you very much. Ray Baker, Almogia, and then we have Ormogia and Card Prager Brusha. Good afternoon, sir.
Good afternoon. First, Ray Baker, Lamar Advertising. I'm the Vice President and General Manager for the Los Angeles market. First of all, I'd like to thank you for bringing this issue back. Again, we know how painful signs can be sometimes. We'd also like to personally thank Alan and Daisy and their staff for their very hard work and due diligence. 3 issues that I'd like to echo that Alan brought up that we thought were important were reduction and relocation, as well as re-permitting, and the settlement agreements, as that's going to echo out in the summit decision later this year. Primarily reduction and relocation, we believe that does give some benefit to the city to solve the current problems with those signs that were handled under settlement agreements. We also believe that helps with the blight and the issues that some of the folks here today have brought about, especially in parks, which we really have no intention of building in parks, but we do want to build in commercial areas and take them out of residential and areas that we believe are near and dear to some of the folks that are here in the constituents of LA. Thank you.
Thank you, sir. Good afternoon.
Good afternoon, council members. My name is Al Moja. I reside at 1812 West Silver Lake Drive. I came here to express my opposition to commercial signs in public parks. Public parks were never intended to be places where advertisement would be. They were intended to be places of relaxation and respite from the daily lives. Frederick Homestead said that public parks should be places of refreshment, mental refreshment, and public commercial signs will only degrade from that. And I find that it's not a good idea for the city of Los Angeles to go to our parks to get financial support from our parks revenue, and also our public libraries too. And it hurts the very people that need these low-cost and free elements the most. So I hope that this element of commercialization, signs, advertising in parks can be eliminated. I don't think it's in the best interest of the people of Los Angeles and reduces our quality of life. Thank you.
Thank you very much. Carol Prager Bushel, Laura Salagi, Dennis Hathaway, and then Barbara, I believe it's Broyd. Good afternoon, ma'am.
Good afternoon. My name is Laura Salagi. I'm representing the Venice Community Coalition. I've lived in Venice since 1973, and I have to object to the idea of city property, any city property used for off-site signage, not just parks, not just the ocean front. And we know that this has been planned because we know that the Parks Commission was thinking about this and plotting out how they could put advertising in parks last year. So this is not something out of people's imagination. Parks aren't the only place that we want to guard against this sort of thing. Just any loophole in this ordinance will create some advertisers' imagination to run wild and figure out a way to put advertising on anything, even on parking lines in a parking lot. And lastly, I just want to say one thing that's very important to me, and that is that exceptions in anything make the community tired. It means that there's never any assurance that we have legislation that we can count on. Thank you.
Thank you very much. Dennis Hathaway.
Good afternoon. I'm Dennis Hathaway, president of the Coalition to Ban Billboard Blight. I spent a lot of time at the City Planning Commission hearings on this ordinance. They had 3 public hearings. They spent many hours taking testimony from stakeholders, from business interests, from community, and came up with an ordinance that I think balanced those interests and represented a consensus. Unfortunately, this report from the Planning Department right now seriously undermines that ordinance that was passed by the City Planning Commission in 3 major ways: by grandfathering all these sign districts, which will mean a big potential proliferations of signs without any commensurate takedown. Comprehensive sign programs did not allow any off-site signs by allowing an avenue for off-site signs. You've already heard what that means. And perhaps most importantly, the City Planning Commission did not allow any digital signs pending a complete study and development of regulations of the effects of on-site digital signs. Thank you.
Thank you, sir. Barbara Broyd.
Good afternoon, Chairman Reyes. My name is Barbara Brody, Westwood, south of Santa Monica Boulevard Homeowners Association. Also bring position Westside Neighborhood Council opposed to the ordinance as currently written. I too attended many of the hearings at the City Planning Commission and believe that this ordinance as proposed is a major change in direction. If indeed you want to find matters of consensus, you probably need to go for the enforcement and penalties and leave out the grandfathering discussion as well as digital on-site signs. The grandfathering has been described as allowing projects in the pipeline to go forward. I would tell you that I would say that's in the gift line. This is Christmas in August. There were 2 sign districts that were appropriately considered by the CPC. It's now 9, 11, 10, whatever. Not appropriate. Pending those that had applied and had approved plans, pulled permits, those are sign districts. The others are not. On the digital on-site signs, we'd ask for an ICO immediately. One of the roles of city government is to protect safety and health of its citizens. Digital signs are dangerous. There are pending federal traffic safety studies underway today that will tell the city whether those signs should be or should not be allowed and how much they distract. We should wait. It's dangerous.
Thank you very much.
Thank you.
Thank you very much. We have Stephen Resnick, Jessica Parkman, Joseph F. Young, Kale Rogers, and Marsha Hoskin. Hi. Good afternoon, sir.
Good afternoon, Chairman and council members. Stephen Resnick, representing as president of the Westwood Homeowners Association, representing approximately 3,000 homeowners in Westwood. We recognize the work that Alan Bell and his staff has done and that you all have done, but we also think, as other speakers have done, that this is not ready for prime time yet. With the proliferation of digital billboards, the grandfathering in of some of those sign districts, we don't think that's appropriate at all. And I would also say within a few words, Yogi Bear and Homey Park. And it wasn't that long ago that Warner Brothers was going to get a huge windfall by plastering Homey Park in Beverly Hills area, and the stakeholders and neighbors and from around the city came out completely against this, and it's not there. And if you do it, the same thing's going to happen again. This is just not right. Thank you very much.
Thank you, sir. Right on the nose. Jessica Pugman, good afternoon.
Good afternoon, Jessica Pactaman with Craig Lawson and Company at 8758 Venice Boulevard. I want to thank staff, especially Alan and Daisy, for their hard work and effort on this ordinance. We generally support the ordinance, but also have some concerns with the current language regarding the establishment of sign districts. The minimum recommended threshold of 5,000 linear feet of frontage or 15 acres is too large. To apply for a district as an applicant, signatures and involvement of 75% of the property owners is required. As a representative of the Figueroa Olympic Sign District, which has been pending for 4.5 years now, I can tell you that from firsthand experience that the involvement of multiple property owners to establish a sign district is quite challenging. Currently, we're at 1 block or 3 minimum acres to meet the threshold, and we only have 4 property owners. Revising that minimum threshold for new districts to 5 times larger, the current acres requirement will make it virtually impossible to initiate any new districts due to the large number of property owners involved. And it makes sense for urban areas characterized by high-rise buildings such as downtown.
Thank you, ma'am.
Okay, thank you.
Thank you. Okay.
Hi, I'm Gail Rogers. I live in Venice, and I'm on the Oceanfront Walk Committee of the Venice Neighborhood Council. It's the one thing in Venice we're all agreed upon, believe me. Homeowners, renters, people without homes, everyone's opposed. And ditto on everything about degrading our quality of life. There's an expression in Spanish, me río por no llorar. Roughly translates, I'm laughing because otherwise I'm going to start crying. Okay, maybe you'll laugh. As students exit Westminster Avenue School in Venice, there are 2 signs that were put up by CBS Outdoors for the recent movies. One's for Bad Teacher and one's for Crazy Stupid Love. So as the students exit every day, they see 2 signs. One says Bad Teacher and the other one says Stupid. Thank you.
Sorry about that. Okay. Good afternoon, sir.
Good afternoon, Mr. Chair and committee members. My name is Joe Young, and I'm on the executive committee of the Angeles chapter of the Sierra Club, which boasts over 40,000 members throughout Los Angeles and Orange counties. I won't repeat the remarks of several others about parks. I would like to add that nowhere in the Planning Department memo or the proposed ordinance is the impact on our city parks themselves considered. Language permitting commercial signage in any form, repeat, in any form, in our city parks should not be included in any ordinance about signage. Such signage should, in fact, be banned. Thank you.
Thank you, sir.
Honorable Council members, Marcia Hanscom, representing the Wetlands Defense Fund, Biona Institute, and CLEAN, projects of the International Humanities Center. First, I want to say thank you for a little bit of a shift from 2.5 years ago, where on page 4 you have said that the current 600 acres of the Biona Wetlands Ecological Reserve cannot be a sign district. However, you have specified that it is an ecological reserve as defined by California Fish and Game. It's a very strong possibility this land is going to be transferred to the State Parks Department. And so we would ask, since there are other state parks in the city as well, that you also say that signage should not be within 500 feet of any state park property or state ecological reserve. As well, we have city lagoons, the Del Rey Lagoon, Biona Lagoon, Grand Canal Lagoon, and these also should be exempted. And I'm also very concerned about the Port of Los Angeles, where we have significant pollution issues. And this community, without a city council member currently representing it, really should not be deluged with this billboard pollution as well. Thank you,
ma'am. Jacqueline Kerr, Doug Arsenal, James Carpenter, I think, and Jennifer Merced. Come on up. Good afternoon, ma'am.
Good afternoon. I'm Jacqueline Kerr, the Greater Griffith Park Neighborhood Council Planning Zoning Committee. And we've had an awful lot of information given to us today. The 5,000 feet of street front and 15 acres. And now that's easy to put in the middle of downtown Los Angeles and in a heavily commercial district like Hollywood. But if this is going to expand, and the way we're talking about raising revenue, it's going to expand, and there will be these SUDs everywhere. There's an awful lot of residents that are going to be really upset with, 15 acres or 5,000 feet of street front. That's not going to be easily factored in. It's going to be a real problem, and City Attorney's Office feels that all of this can get too personal, the right of redress or object, at any rate. Don't leave us without an avenue to object. Don't leave us without a way to get rid of the signage that's coming into our bedroom windows. Thanks.
Thank you, ma'am. Next speaker.
I have a policy brief.
Okay.
Thank you, most esteemed council members. My name is Doug Arsenault with the Valley Industry and Commerce Association. VICA wants to applaud the work of the City Planning Department, particularly Tom and Daisy, in making these necessary changes to the city's sign ordinance. We're supportive of the revised sign ordinance. However, a few amendments need to be made to reflect the realities of our city and its industries. First, the minimum 5,000 feet, 15 acres threshold for sign districts is far too large, limits the flexibility necessary to enhance dense areas. The restriction against abutting freeways, which hasn't been discussed, is similarly unrealistic of Los Angeles, as the city, particularly the San Fernando Valley, is built around freeway access. We're also deeply concerned about the extreme and unnecessary punitive proposed penalty structure, particularly for on-site signs, which are by their nature non-revenue generating. On the topic of on-site signs, the use of exclusively in the definition of an on-site sign will lead to misclassification of de facto on-site signs that feature cross-promotional graphics. On the topic of digital displays, the 350,000 candelabras daytime requirement does not account for inclement weather or sunlight changes throughout the day, which may reflect visibility.
Thank you very much. Good afternoon, ma'am.
Hi, my name is Jennifer Merced, and I'm a resident in Sherman Oaks at 14622 Killian Street. I'm here today to oppose signage in city and state parks. I want to say that the LA Park and Rec and Parks website has a mission statement that says it wants to teach community members and children to be good stewards of their environment, and that they will use facilities to reflect the public needs and interests, which is a very different thing from projecting the private needs and interests. And I want to say that you can't teach children and community members to be good stewards of their environment if you're not demonstrating the conservation ethic. What children are not taught to respect, they will not work to save. I want to point out a couple of facts from the University of Michigan Institute for Social Research, and something I found also on the BLM program website entitled Take It Outside, which is namely that American children can recognize 1,000 corporate logos, but they can't identify 10 plants and animals native to their own region. Childhood obesity is up 30%, and one last statement, basically that children spend 90% of their time indoors, and take that into consideration. Thank you.
Thank you, ma'am. James Carpenter, and then we have Shiraz, I think it's Tangri, and then Richard Spicer. Good afternoon, sir.
Hi, James Carpentier here on behalf of the International Sign Association. And first, I'd just like to thank planning staff, Alan and Daisy. Being a planner of over 20 plus years in the private and public sector, I fully appreciate and understand the comment that Alan made on the complexity of what you're dealing with right now. Overall, we're really happy with the draft and pleased with the draft, and urge the adoption of the draft. But we have a couple issues I just wanted to bring forth. And it has to do with the sign district. The area is being a little excessive, and you've heard this before. We understand that the rationale to create a sense of place, but a one-size-fits-all approach in a city as diverse as LA is difficult. And there would not be really a worse time to take away options from decision makers at this time to be able to have this option out there. This would take that option away in many instances, in many cases. And so we respectfully request that the existing sign district area of 3 acres be maintained. Thank you very much.
Thank you, sir. Next speaker. Good afternoon, sir.
Afternoon. I'm David Garfinkel, President of Tarzana Property Owners Association. We like some of the provisions and changes in the ordinance, but we have several objections. A lot of objections have been raised throughout today's hearing, but let me mention a couple more. One, let me reemphasize against the idea of grandfathering additional sign districts. Number two is, I've looked at this a good deal, and I really don't see any justification at all for the comprehensive sign program. Just doesn't make a whole lot of sense. I don't see where it adds anything. Three, I think we need to retain the right of private action. Private action is what overturned the city's implementation of SB 1818. We need to retain that kind of access for signs. Last of all, I think we need to talk more about removal of non-permitted signs. We're not talking about signs that are just non-conforming, but signs that were
Thank you, sir.
That were put up without permits at all.
Thank you very much. We have Shiraz Tangri, then Richard Spicer, Susan Borden, then Ryan Brooks. Good afternoon, sir.
Good afternoon, Shiraz Tangri of Elstenburg. I want to join with many folks here representing businesses in thanking the Planning Department for working through many of the complicated issues and keeping intact some of the critical provisions of the existing ordinance. I think that level of continuity provides a lot of assurance for a time when businesses have tremendous uncertainties, and I think adding to the difficulty in signage would only make Los Angeles a less attractive place to do business. One continuing concern is the sign adjustment fee. That fee we're concerned will be prohibitively expensive for the majority of potential applicants. The fee would be almost $6,000 versus the cost of a sign being approximately $5,000, and we're concerned that by having an elevated fee, there's a greater risk that you'll have illegal signage when people simply can't afford the permitting to justify the changes to the sign that are often necessary for even small size signs. Thank you.
Thank you, sir.
Good afternoon, members of the committee. My name is Richard Spicer. I'm here representing the board actions of the Greater Griffith Park Neighborhood Council. You had community impact statements at 2 previous meetings, all your bodies. Those did not show up in the agenda today. I spoke to Michael. He's going to check into that. I'd appreciate, on behalf of the neighborhood councils throughout this city, that when the CIS is put in, it is honored and put on the agenda. So among the many points there are the fact that neighborhood councils ought to be notified. Effective enforcement has always been a very important part of the neighborhood council. So the special unit that's proposed looks as though it could go in that proper direction. So do the penalties proposed. This proposal is so complex, it will take a special unit. Our neighborhood council several years ago took pictures and all the data on every sign in the neighborhood off-site. We are still waiting to find out which ones are legal and not legal.
Thank you, sir.
There are more comments in...
Please submit them in writing.
Thank you very much.
For the record. Thank you, sir. Susan Borden, Ryan Brooks, Benjamin Hanlon, and Phil Rick. Hi. Good afternoon.
Good afternoon. Susan Borden, I live in Echo Park. I thought most of these proposals seemed very well thought out, especially the large size of the sign districts. However, I am very much opposed to ads on city property, especially in parks. I don't think ads are ever appropriate in any park, any more than we would want posters on the front of City Hall. And I'm very shocked by the proposal that would even open the door for ads in the park, and I think that's unworthy of Los Angeles.
Thank you. Good afternoon, sir.
Ryan Brooks, CBS Outdoor. Mr. Chairman, members of Plum, thank you for your leadership. Also want to thank the planning staff for their great leadership on this very difficult issue. I also represent the coalition of 90% of the legal signs here in Los Angeles. And I agree with the people back here talking about signs in parks. We don't want them in parks either. So we will support any amendment that we can do to make sure that our billboards are not in parks. One of the things we want to look at is some of the best practices. We've seen billboard ordinances, throughout the country. In the city of Oakland, our then Mayor Jerry Brown, our governor, created a reduction relocation program. What it did was reduce the total number of signs in the city of Oakland, created new modernized signs, and actually funded the Oakland School of the Arts, which is a fantastic program right now. And we think the city of Los Angeles can look at those best practices and do it also. On the enforcement side, we love enforcement. The heavier, the better, but it has to be done right. One of the things we want to work with the planning staff on is create a process like in the city of San Francisco. They have a process of administrative law judges go and doesn't cost the city any money, and it's part of the best practices, and it's a way forward. So hopefully you'll take these recommendations. Thank you for your time, and no billboards in parks.
Thank you so much. Our next speaker.
Good afternoon, Honorable Chair, Council members. Benjamin Hanlon with Latham & Watkins on behalf of Clear Channel Outdoor. We echo the many thanks that staff has received for its efforts, but there remain some critical areas requiring close consideration now. First, coordination with other related and pending ordinances is required. For example, the Administrative Citation Enforcement Ordinance enforcement procedures overlaps with the sign ordinance's procedures. The ACE ordinance is pending before the Budget and Finance Committee now, and we ask that it be referred to Plum so these two ordinances can be coordinated. Second, this committee is also scheduled to hear revisions to the off-site sign inspection program in September, and coordination is required between that ordinance as well to ensure consistency and conflicts later. Lastly, the sign ordinance should contain its own administrative appeal process. This administrative appeal process needs to provide a reasonable opportunity to cure any violations. 15 days is too short. It should be 30 at a minimum. Second, there should be an expedited appeal process, as the gentleman just referred to, the opportunity to go to an administrative law judge at the cost of the sign operator. And third, all fines should be stayed pending the
and your name
resolution
again,
of an
sir?
appeal.
Your name again?
Benjamin Hanlon.
Thank you, sir.
Thank you.
Good afternoon.
Good afternoon. Phil Recht of the Mayor Brown Law Firm. We represent Summit Media, which is one of the smallest of the off-site conventional billboard operators here in town. We just want to support the suggestion that Mr. Bell made this morning about adding a relief provision to this ordinance at this time for these minor permit deviations. As Mr. Bell indicated, there's a similar relief provision for on-site signs that's included, the sign adjustment provision. The largest off-site companies that represent 97% of the market have similar provisions already in their settlement agreements. So as a matter of fairness, to ensure a level playing field, it's necessary to offer something similar for Summit and the other small operators of these conventional billboards. Let me suggest two things. One, this is not controversial. We're dealing with minor deviations. These are not the kind of major issues that have led to the controversy in the city about new signs and proliferation of supergraphics and digitals and the like. Secondly, as Mr. Bell suggests, this is a relatively easy and straightforward issue to deal with. You can draft it up pretty easily, and therefore we hope you'll include it in this ordinance. Thank you very much. Appreciate
it. Issa K. Mixon. And then we'll have Beth Gordy, David Goldberg, Nancy Friedman, and a few more cards, and we're in the home stretch.
This book, Creative and Mental Growth, was written by Victor Lowenfeld and was required reading for an art course I took for my credential for special education. I should be required reading of city council members, the courts, and every adult. You would never impose ever again a coloring book on children or a Yogi Bear type image in a public park. Children create from a very different emotional wellspring. And the imposition of these kinds of images, especially in parks where children are finally free, I can't summarize 508 pages. Please read it. It will revolutionize your attitudes about art, children, and not imposing upon them.
Thank you, sir. Good afternoon. Next speaker.
Good afternoon. I'm Beth Gordy with Latham & Watkins. Previous versions of the draft sign ordinance included provisions for a definition of what constitutes a specialty sign within a comprehensive sign program. We request that this committee direct planning staff to reinsert this provision into the sign ordinance. The comprehensive sign program should provide for a definition of what constitutes specialty signs for developments with unique sign needs, such as our entertainment, sports, cultural, shopping, and academic facilities, to clearly identify what signs may be considered on-site signs. Examples include donor signs, sponsorship signs, and signs associated with temporary promotions. The Council previously approved such donor and sponsorship signs as part of the LMU specific plan. These are exactly the types of signs that should be permitted through a comprehensive sign program, as donors and sponsors invest in Los Angeles, are critical to the success of these important facilities, and are essential to job creation. Thank you.
Thank you, ma'am. David Goldberg, Nancy Freeman. Good afternoon, sir.
Good afternoon, David Goldberg, Latham & Watkins. We really appreciate all of Planning's hard work and the number of revisions they've already made to address concerns, and I'd just like to focus on a couple additional issues that we request be addressed to avoid unintended harm to the city's revenue and job creators. First, the comprehensive sign program is intended to provide flexibility for larger developments, and Planning's prior draft of the ordinance had provisions that would allow that program to exceed sign area limitations. We ask that that flexibility be restored, particularly because the Planning Commission will be reviewing all of these applications, and through its strict findings will be able to control the signage to ensure that it's appropriately scaled and compatible with the area. With respect to sign districts, we support the request that has been made by others to allow alternative mechanisms other than signage reduction, such as beautification, facade improvements, etc. With respect to some areas that just don't have off-site signs to take down, there needs to be an alternative mechanism, and we think the findings that have already been proposed regarding a sign district addressing visual blight and safety are appropriate, and that's a fair and reasonable solution in those types of areas. Thank you.
Thank you, sir. Nancy Friedman.
Good afternoon. My name is Nancy Friedman. I'm from chair of the Brentwood Community Council, and I want to thank you for your endurance and listening to us. I would like to just mention a few things. I don't even know if I'll take the minute. If you were at a corner and you are watching a sign, if you look over in the next car, there might be someone watching the sign and on the cell phone. We've never even solved the cell phone problem, and now they're distracted by the sign. So this is a really big problem in the city, and I think a traffic study is a good idea to see, in fact, this is really going to cause a lot of trouble in Los Angeles. Number two, the creep factor. You get it down, it gets right, and then all of a sudden, 5 years from now, all of a sudden, signs start creeping in. You need to get this straight and right to begin with. And we would really like community input in our Brentwood community. We haven't had time. This came up really quickly, and it's been a few weeks. And if you could possibly give us some more time to talk to our constituents, they are the public, and we don't like just making an executive decision for them.
Thank you, Ms. Friedman. Thank you very much. Our next group of speakers we have, and this is it, Mike Tarzinski, Beverly Kenworthy, Will Wright, and Amy Freilich, and that would close this public hearing. So Mike Tarzinski, are you here? Beverly Kenworthy, Will Wright, and Amy Freilich, and that's it.
Beverly Kenworthy, Public Policy Director for the Los Angeles Chamber of Commerce. We have submitted 2 letters for you. One, I'd like to echo the comments of the California Sign Association and our concerns about the size of the sign districts as well as the sign adjustment fee. On a more general note, I would like to point out and just really emphasize that the outdoor, or just the advertising industry and the outdoor advertising industry is a part of the Los Angeles economy, and that might be funny to some, but for the people who hold those jobs and depend on those jobs, it's critical and it's important, and we are here to speak for them. It is critical for the entertainment industry. We hear from the studios who are members all the time asking us about this issue and the work that we're doing on it. We believe that we know you're moving forward. We appreciate all the work to date, and we are really looking forward to an ordinance that provides the clarity and consistency that this industry needs that's been lacking for too long. And so we are here to say that a comprehensive outdoor advertising ordinance is good for the city, and we look forward to it being done as quickly as possible. Thank you.
Thank you, ma'am. That's right.
Good afternoon, everyone. My name is Will Wright. I'm here with the American Institute of Architects. I will submit our letter that we have here. I want to say that we do support the process. We're extremely delighted that the planning department has included the professional perspective from AIA. We do have a couple of comments. One would be with the takedown ratio. Perhaps 2 to 1 as opposed to 1 to 1 would be a more equitable and appropriate ratio, and that's referring to the sign impact area. The other, regarding the sign district size, I think perhaps size doesn't matter so much as intent. And if we look at the intent of the sign district to create a unique sense of place, perhaps there is some flexibility there to truly come up with the correct size for that specific sign district, and maybe relate that to the zoning code so that you're not having to play this game whether or not 5 blocks is fair here and 3 blocks is fair there. But I'll submit that in our letter. Thank you.
Thank you, sir. Ms. Freilich.
Amy Freilich, Armbruster, Goldsmith, and Delvac. Let me be the last person to say that I am...
Wait, not just yet. We got one more.
Shoot.
You were so close.
Maybe I will be the last one to say
Oh,
that. We very
so
much
close.
appreciate the efforts of planning staff. I'm here on behalf of AEG. And as you may have seen in the presentation, the Convention Center Modernization and Farmers Field project is proposed for grandfathering. It is very critical to our project that we understand the rules of the road and that they're very clear to us as we move through this signage process, and so we very much appreciate that. We've had an opportunity to speak with Ellen Bell and Daisy Moe with respect to clarifying the grandfathering rules, and we've submitted some suggested language, which we understand they're considering, and we look forward to an opportunity to follow up on that. Thank you very much.
Thank you, Ms. Freilich. And last speaker, Stephen San.
Thank you very much, council members. My name is Stephen San. I'm the chair of the Westwood Community Council and the chair of the Westwood Village Business Association. Also want to thank you for your focus. One after the other, we've seen the lawyers and the lobbyists come to this microphone and thank the staff, but I don't think I heard a single representative from a neighborhood council or a community council do that, because frankly, we've been pretty much shut out of this process since the ordinance was approved by the Planning Commission. So I understand why the industry is very happy with this proposal, but you should take note that the public, the voters, those of us who depend on you to look out for the interest of the city and for the interest of the citizenry, we're not so happy with it. So I would like to respectfully ask that you not at all approve this today, and you give the communities, the neighborhood councils, an adequate time to understand what has been put forth and to comment on it. Next, I would like to focus on an issue that I don't think I've heard at all, and that is the cumulative impacts. Please understand that this ordinance doesn't stand alone. We have the CBS Deco street furniture program that plastered this city with advertising. We have digital billboards that were approved by our previous city attorney with no public input. We have bench ads that are coming before planning or public works. We have trash cans that now are going to have ads. We have AEG. The point is, what's happening before you today is it's almost a race to the bottom for the ugliest city. So I ask that you please not approve this today.
But just one point of fact. I did hear some committee members thanking the planning staff as well. I did hear that. So it just wasn't all one-sided, but point well taken. That being said, just a moment, please. Okay. So we've had a pretty long public hearing, and it's been stated we've had several already that occurred during the commission. Today was about getting this out in the open, allowing the committee members to receive this information, and now we want time to digest it. There's a lot of detail here, and it's just the beginning. This is the first, how can I put this, the first approach, a foundation. There'll be other layers coming in as we continue to work on this living document. But I do have a couple of questions I'd like to ask the staff. I know this has been painful, but we're almost there, at least for today. But we do have a couple of questions, I believe. And when we look at, I'll just put it on the record, why are streetscape improvements or other beautification options not included as an option or in conjunction with sign reduction within the sign district?
I mean, clearly it's a policy choice, and we feel that our recommendation is based on the fact that the Business Profession Code doesn't provide us a lot of opportunities to reduce signs. Relocation agreements, sign districts, those are the only viable tools that we would have to reduce the existing inventory, significant inventory of off-site signage in the city of Los Angeles, over 10,000 billboards. So it is possible. It is possible to include. It is, yes, it is possible. I think that a community beautification alternative that would be consistent with the rulings that came out of Worldwide Rush. Whether it's preferable is an open question. And so our recommendation is based upon the idea that we should, as a city, do as much as we can through the policy tools we have on the plate to reduce that inventory of signs.
So moving forward, do we have enough exposure to other cities, and or can we cultivate the language that allows us to consider that possibility within the policy?
Hi, Daisy Mo again. If I could just add one more thing on this topic. One of the difficulties with having a community beautification option is in quantifying that beautification. So in other words, how many street trees or how much streetscape improvement equals one new off-site sign. So that's been one of the issues.
Okay.
We did look at other cities. We didn't find a comparable program.
Okay, but it's just something we have to craft if we go there. Okay, right. And that's probably part of the a directive that I'm hoping we can leave with, is to create the mechanism, the financial vehicle that allows us to fund the necessary staff and or analysis to get to some of these equations and or nexus issues. The other question I have is, in the planning report, there's reference to follow-up items. Does the planning department currently have the resources to work on these items? And it kind of lends to what I just said, but...
No, it does not, Councilman.
Okay, and that's a nice, quick answer. So, planning department's been cut 40%, right?
That is correct.
And I'll be a broken record on that one to my colleagues. And therefore, we need to establish that capacity.
Our recommendation as part of our prior budget request, for the current fiscal year, was to establish a sign unit. We see the sign unit's responsibility as being twofold. One, to be a specially trained unit to review these applications for sign districts and other sign-related discretionary actions, number one, and then number two, to focus on the citywide policy issues that are the concern of the council and the community, including digital signs and regulations for digital signs, revenue generating potential, relocation agreements, re-permitting.
Okay. I do want to take a moment to thank Building and Safety. I see you guys there. Thank you. I know you guys have been the implementers throughout this process, so I appreciate your presence as well. Colleagues, any questions and or observations for the staff before I get into instructions and follow-up?
No, I just want to also thank the staff. I know this is a lot of work. All the different stakeholders that my office spoke to recognize the fact that they were being heard, and it's a long process. I think at the end of the day, not everyone will be happy, but I think we're trying to find that balance in terms of what is the best way to move forward with a very complex and complicated manner. Initially, I was thinking that it was best for us to move ahead and do address all the issues associated with signs in the city of LA, but as I started looking at this, I realized this is a better approach to kind of take each one of these as you frame them and move forward with the different sections of a large complex issue, and with moving litigation and everything else, it kind of makes sense to try to take these on separately as we move forward. The only one question I do have, I have a number of questions, but I think as we, in the interim, since it's been a long meeting, I'll address them to the planning department and hopefully have them answered before we get them back onto the next Plum. You hope to have this back to Plum, or it's not going to the full council, right?
No, it's going to come back here.
Okay.
I don't think we're ready yet. I think we still need to vet out some of the concerns and issues and get clarity as to the charter role of the park commission and the council and all that good stuff. So,
the one question I do have, do we have the database of all existing signs in the city of Los Angeles? Has that been completed?
My understanding is we do have a database of the off-site signs, certainly nothing comparable for
The
on-site.
Okay, the off-site. Now, there's a lot of interest by the different stakeholders in the community about what off-site signs exist. How can they access that information?
Building safety is the department that would have a database of the existing off-site sign. I mean, there is an off-site sign inspection program and fee. If they should be able to answer that particular question.
Who manages ZEMAs?
ZEMAS is managed through the planning department.
Yeah. Would it be possible to post some of that information through ZEMAs? Right now, when your average resident is looking for some public information on land use issues in the city, the first place they go is ZEMAs. Would it be possible to put some of that information in ZEMAs?
Certainly, that's something that we could take a look at, talk to our systems folks, both in the planning department and in building safety, whether we could transfer building safety's database and then put that information on ZEMAS. We can report back about the feasibility of that.
I think it would be helpful both to address the issue of the legal and illegal signs, and also once this ordinance gets implemented and people have questions about the proper size and square footage and where the sign districts should exist, a lot of that information would be answered by technology rather than having all those phone calls come to the planning department. So that might be something worth looking at.
I think it's a great idea.
Great, thank you.
Fantastic. Councilman Kokorian, any comments or questions?
I have many, but given the lateness of the hour and your recommendation, which I support, of bringing this back to Plum for further consideration after planning has had an opportunity to further refine some of these things in light of the public's comments, I'm happy to defer until the next discussion.
Great. Thank you, sir. That being said, I'd like to instruct the planning department to include the streetscape improvements and other community benefits as part of the sign ordinance to allow for sign reductions, and we'll give it a shot and then see where we can take that. Instruct the CAO and the planning department in consultation with the CLA to work on setting up a fund in the system where funds can be deposited by private industry for the purpose of creating a sign unit within the planning department. The purpose of the sign unit is to have planning department dedicate full-time staff and hire a consultant to work on the follow-up items outlined in the report. Again, I'll play devil's advocate. Well, I know what we're going to hear is that, well, they paid for it, therefore they're going to get what they want. The truth is, we in the planning department do work with consultants. They do provide information. The planning staff vets out, they vet the whole, everything that's provided. It's the planning staff that provides the instruction, and we're going to debate whatever comes forward in this body, and we're going to make this as transparent as it should be. So that's where we're going to take this, but we don't have the staff now, and we don't have the money now to hire staff to do this work. And that's the fundamental fact. I think we need, is it 4 to 5 individuals or 3 to 4? What is it that we need to reach?
I think that we would need 3 to 4 staff to carry out the work program that we've outlined, both the individual applications as well as the policy issues, and then also funding for consultants that have expertise, particularly on the economic components related to signs and relocation agreements.
And when we talk about economic components, we don't want to put ourselves in because of ignorance and or lack of information, the true value of some of these potential nexus issues and or equations and ratios that will affect our ability to perform and protect the city in as much as stimulate environments for investment. So that's the balancing point we're going to try to achieve. And that would be the reason why we need to create this fund. Lastly, I'd like to have the planning department report back to Plum with any changes and or follow-up reports on October 18th, 2011. And that gives us enough time to work on this. The advocates that are here, you have time to speak to your council offices, to your commissioners. Everyone has the flexibility to approach decision makers and raise your issues. And again, we're going to do everything to make sure that we are being transparent. But I think this will get us to the next level, and hopefully by that time we'll have more news from the city attorney's office in terms of where we're at with our cases and impacts in our policy making. So that being said, I want to thank everybody for their patience, and we'll continue moving forward, and good luck. Okay, so does that conclude, Roberto, all of our items?
Yes, sir, public comment.
All right, anybody here for public comment? Seeing none, this meeting is adjourned.